let's talk about trusts, because there's a lot of misunderstanding about trusts. And when you hear the term trust, that's like just the start of the conversation. Is it a revocable living trust? Is it an irrevocable trust? Is it an inter vivos or a lifetime trust? Is it a testamentary or a trust that is created through a will on death? So just saying the term trust actually should raise more questions for you. So I am going to talk about how trust can protect you during your lifetime and how trusts don't protect you during your lifetime. The majority of trusts, when you hear the term trusts, are what are called revocable living trusts. That is a standard estate planning tool. The reason it is a standard estate planning tool is that a revocable living trust is intended to take the place of a will and a probate, because a will is something that needs to go through probate on your death. Probate is a court proceeding. Probate ensures that the will is carried out as it should be, that the assets go where they're supposed to go, that it is done correctly, because the court is there in order to make sure that that occurs. So you have a personal representative or an executor appointed, they need to carry out their job, but if they don't do it like they're supposed to, then there's the venue for making sure that they do carry out their job or replacing them or whatever. So I said court, right? What does that mean? That means there's going to be legal costs. I mean, people try to do it yourself probates, and that's fine. And some people might be able to do so, but typically you are going to need the services of an attorney to do a probate. And whenever you're hiring a lawyer, that means you're going to be paying the attorney, and that means you are going to be, there are going to be fees involved. And legal fees, of course, are going to be higher than, somebody who's a bookkeeper, for example. So a lot of people want to avoid probate. And I forgot to mention, in other states, not Washington, not Idaho, but in other states, the legal fees of a probate are going to be tied to what's the value of the estate. In Washington and Idaho, we don't do that. The legal fees are tied to how much work was it? How good was the estate plan set up? How easy is it to do this estate? Did the court not need to be involved at all? We just had a non-intervention probate. We just filed the will and the petition, and then the court isn't involved at all, which is how typically a probate will go. But in other states, they look at what's the value of the house, and then the probate fees are tied to that. So of course, in states where the fees are tied to the value of the estate, you're going to want to avoid a probate, but that is not Washington. So in those states, a revocable living trust is a commonly used estate planning tool to avoid probate. In Washington, it certainly can be used as well. One of the things that is important to understand if you have a revocable living trust and you're in Washington and you are a couple, is that there are very powerful asset protection tools that don't come with having a revocable living trust, that only come with having a will. For a couple, for example, if the first spouse dies and they have the right kind of will with an asset protection supplemental needs trust, we can protect half the couple's assets from Medicaid from long-term care costs. You cannot do that with a revocable living trust. So there are very good reasons to have a probate. Not all estates need to protect assets in that manner. Sometimes a revocable living trust is appropriate, even in Washington, to avoid a probate. But what's important is you understand what your situation is. Don't just go with a revocable living trust because somebody said, oh, you avoid probate. Find out what the benefits of probate might be. Why might you want to go through probate, your will? Why might you not want to have a revocable living trust? I can tell you from the revocable living trusts that we see, oftentimes the problem with them is that they are not funded. If they're not funded, in other words, let's say the bank account isn't titled in the name of the trust, or the house is not titled in the name of the trust, the trustee of the trust, then there will be a probate, plus there'll be a revocable living trust administration. So with a revocable living trust, it's not a sign it and you're done. It's a sign the document, fund the trust, manage the trust for the rest of your life. You get new assets that are titled, they need to go in the trust. You buy a house, sell a house, it needs to be done through the trust. So keep in mind, if you have a revocable living trust, it's a document that has to be changed and managed as you go through your life. One of the things that people believe that a revocable living trust does, but it does not do, at least not in the state of Washington, is it does not protect assets for you at all. You get sued, your revocable living trust is a see-through entity, just like you owned it outright in your name. Having it in a revocable living trust does not in any way protect that asset from your loss of the asset if you get sued by a creditor. So don't fall for this mistaken notion that a revocable living trust, at least in Washington, protects assets for you. It does not, period. What kind of trust might protect assets for you that you create during your lifetime? An irrevocable trust can protect assets for you against creditors, against claims, but it must be irrevocable. Irrevocable means you gave that asset away. You no longer own it. This irrevocable trust has its own tax ID number. It doesn't use your Social Security number. And the whole idea with an irrevocable trust is you can't get that asset back. You gave it away. Irrevocable trust can be very useful for Medicaid planning, tax planning. You can't use it if you're trying to avoid creditors that you believe are going to be coming after you, because that's defrauding your creditor. So irrevocable trust can be a very useful planning tool to protect you and to protect your assets. You'll definitely want to talk with your attorney about it. You do not do an irrevocable trust on your own. Other ways what I just talked about, revocable living trust and irrevocable living trust, I was talking about them from the perspective of what you create while you're alive. Keep in mind that you can create trusts through your will after your death. And you can create trusts for your kids, for your grandkids, special needs kids, for your spouse. If you, in your will, have this supplemental needs trust for your spouse, on your death, what happens is the assets that are yours. Let's say you're in a community property jurisdiction like Washington, you own 50%, your spouse owns 50%. You have $1 million estate. You die first. Through your will, through the probate, your $500,000 share of the estate goes into this special trust for your spouse. That ensures that your spouse will never become impoverished, no matter what happens, even if they need expensive long-term care. Why is that? Because the assets that are in the supplemental needs trust are not counted by Medicaid. They do not interfere with eligibility. They are not subject to any creditors, to any taxes on death, inheritance, estate taxes, once they are in that trust, when the beneficiary dies. Creditors can't get at them. So not only do you ensure that your spouse has that nest egg, but then let's say you have 2 kids and you wanted to make sure your kids get something, that $500,000, what's left of that, is going to be divided between those 2 kids. So you ensure that assets go where you want them to go and they're protected. That is done through a will. And recall, a will that creates a trust, that trust is called a testamentary trust. So testamentary trusts are very powerful asset protection tools. How do you make sure that you have that for your spouse or other beneficiary who you want to make sure they have asset protection? During your lifetime, you do create a will that has those protections in it.